Chat box कहाँ है?
I now request the prosecution to kindly approach the dais and proceed with their arguments.
Counsel seeks permission to address the bench.
Please go ahead.
Much obliged. With the permission of the court, counsels shall address this court as lordship individually and collectively as your lordships. Your lordships, I, along with my co-counsel, will be representing the state in the matter
Mr.
of...
Sharma, can I take the liberty to tell them not to address as your lordship?
Yes, definitely.
I mean, we are all, even at this informal level, we are going up with that archive. Anarchy. You can address as private man, I think, isn't?
Yes.
Yeah, or anything but your lordship and my lords.
Yes.
Yeah, thank you.
Much obliged, ma'am. I, along with my co-counsel, will be representing the state in the matter of State versus Rakesh Kumar and others. Counsel seeks permission to state the facts of the case.
Okay.
Much obliged. The prosecutrix, a young girl of just 15 years, was walking towards her school on 2nd February 2022 at around 8 a.m. On her way, 4 persons, namely Rakesh Kumar, aged 16, Anuj Kumar, aged 26, Anil Kumar, aged 27, and Anuj Kumar, aged 30, kidnapped her at gunpoint with a katta on 2 motorbikes and took her to a vacant plot. All 4 accused committed the brutal and inhumane act of rape on the prosecutrix. They could not hold back her scream, and this alerted the neighbors who came to her rescue. The accused were left with no choice but to escape. While doing so, accused person Rakesh Kumar fired towards the residence with the katta. It fell on the ground, which was picked up by the accused person Ajay Kumar, and all persons fled the crime spot on their motorbikes. The minor girl was bleeding from her private parts and was screaming in agony. She was immediately rushed to the hospital where the various legal and medical procedures took place. The accused in the present case have been charged under Section 376DA, Section 363, read with Section 120B and Section 34 of the Indian Penal Code, Section 6 and Section 8 of the POCSO Act, Section 18 and Section 23 of the JJ Act, and Section 25 and 27 of the Arms Act. Counsel will be dealing with the charges relating to the Indian Penal Code and Arms Act and will take up 18 minutes, while my co-counsel will be dealing with charges relating to JJ Act and POCSO Act and will take up 18 minutes. We will be reserving 9 minutes for rebuttal. With the permission of the court, counsel would like to proceed with the body of arguments.
Yes, proceed.
Counsel would like to divide the first issue of charges under IPC into 4 limbs. The first limb will be proving Section 376DA. Observed by Justice Arjit Pasiat, while a murderer destroys the physical frame of the victim, a rapist degrades and defiles the soul of a helpless female. It is submitted before the Honorable Court that the 4 accused persons in the present case have committed gang rape on the prosecutrix. This can be understood from the various testimonies provided by the prosecutrix as well as the eyewitnesses and the medico-legal report of the investigation. In the present case, the victim is a 15-year-old girl child. Therefore, the question of consent doesn't arise. The testimony of the prosecutrix is clear and unambiguous. She was kidnapped and raped on gunpoint by the 4 accused persons. In the case of Sham Singh versus State of Haryana, mentioned in page 15 of the memorial, it is stated that courts must not hesitate in relying upon the victim's testimony as the sole evidence for convicting the accused unless there are compelled reasons to look for corroborative evidence. In the case of State of Maharashtra versus Chandraprakash Kevalchand Jain, also mentioned in page 15 of the memorial, Supreme Court held that a woman who is the victim of a sexual assault is not an accomplice to the crime, but a victim of another person's lust, and therefore her evidence need not be tested with the same amount of suspicion as that of an accomplice. The Evidence Act nowhere says that her evidence cannot be accepted unless it is corroborated in material particulars. The Supreme Court in Ausu Verghese versus State of Kerala held that minor variations in the accounts of witnesses are often hallmark of truth in their testimony. The Supreme Court again in State of Rajasthan versus Skulk held that the depositions of witnesses, there are always normal discrepancies, however honest and truthful they may be. Such discrepancies are due to normal errors of observation, normal errors of memory due to lapse of time, due to mental disposition of shock and horror at the time of the occurrence, and the like. Counsel would like to bring it to the attention of the Honorable Court the presence of 4 eyewitnesses in the present case, 2 of whom actually saw the rape being committed on the prosecutrix. It is to be noted that the private parts of the prosecutrix were observed to be bleeding by all 4 eyewitnesses when they came to her rescue in the present case. Moving on to the second limb of the issue, the counsel would like to submit that the accused persons kidnapped the prosecutrix to commit rape on her. In the present case, the prosecutrix was going to her school on the morning of 2nd February 2022 when 4 men approached her on bikes and threatened her with a gun pointed to her forehead. She was kidnapped on her way to school, taken to a vacant plot, and raped by the 4 accused persons. It is to be noticed that the prosecutrix is of 15 years, which is a tender age, and the accused persons had a weapon in possession. The prosecutrix was in no position to make a reasonable decision of her own when her life was put at risk. In the case of Chaggu Ram Maru Ram and another was Punjab, it was said that in determining whether a person takes a minor out of lodging of its guardian, the distance to which the minor is taken away is immaterial. The taking which constitutes an offense is completed as soon as the girl is removed from her lawful guardianship. It does not mean a continuing or continuous act. In dealing with the third limb of the issue, counsel submits before the Honorable Court that the accused persons are guilty under Section 34 of the IPC. In the case of Parikshit, ingredients of sex are A. A criminal act must be done by several persons. B. Common to commit participate in the commission of the offense in furtherance intention. I ask if I'm visible. Am I audible and visible to all of you?
There's some obstructions on your side.
A couple of seconds. Can I?
Okay. Okay.
Judges, am I audible clearly now?
Yes.
May I proceed with my arguments?
Yes, please.
Council deeply apologizes for the technical glitches that have happened. Therefore, in the case of Parichat versus State of Madhya Pradesh, ingredients of Section 34 are: A, a criminal act must be done by several persons. B, there must be common intention of all to commit that criminal act. C, there must be participation of all in the commission of the offense in furtherance of that common intention. In the present case, the first ingredient of Section 34 is fulfilled as all the accused were witnessed at the crime scene, raping and sexually assaulting the victim. Accused 1, Rakesh Kumar, was holding a pistol to the head of the prosecutrix, while accused 2, accused 3, and accused 4 were raping and sexually assaulting the prosecutrix. In the case of Ramaswamy Iyengar and others versus State of Tamil Nadu, mentioned in the memorial, page 12, it was held that the essence of Section 34 is simultaneous consensus of the minds of persons participating in the criminal action to bring about a particular result. Such consensus can be developed on spot and thereby intended by all those present. The second ingredient is the presence of common intention. In the present case, the fact that the accused persons had a weapon and traveled on motorbikes together, kidnapping the prosecutrix to commit rape on her, can be understood as common intention. In the case of Sachin Jana and another versus State of Bengal, the Supreme Court recognized that direct proof of common intention is rarely available, and therefore such intention is to be inferred from the proven facts or circumstances of the case. The third ingredient is fulfilled from the criminal conduct of the accused persons. The prosecutrix clearly stated that Rakesh Kumar pointed a gun to her forehead, Anuj Kumar held her legs and tore her clothes, and Anil Kumar held her hands and covered her mouth so that she could not make any noise. The joint participation of all the accused persons in the present case show the third ingredient of Section 34. Moving on to the fourth limb of the issue, counsel submits before the Honorable Court that the accused persons are guilty of criminal conspiracy under Section 120B of the IPC. In the present case, the accused persons carried a country-made weapon, a katta, and used it to kidnap and threaten the prosecutrix to maintain silence while they raped her. It is also to be noted that the 4 accused persons traveled on 2 bikes and coordinated the kidnapping of the prosecutrix, indicating criminal conspiracy. The prosecutrix in the present case knew the identity of the first accused, Rakesh Kumar, which could indicate that she was chosen to be the target of this heinous crime. In the case of Paramhans Yadav versus State of Bihar, it was observed that it is difficult to support the charges of conspiracy with direct evidence, and the way by which one can prove criminal conspiracy is by establishing the link between different chain events. If the judges are satisfied with the arguments of the first issue, counsel seeks permission to move to the next issue relating to charges under Arms Act.
Yes, please proceed.
Much obliged.
My understanding, Justice Sharma will put the question only once they finish it. I mean, it is not a question of being satisfied. You please conclude and then you put the questions. Not that first limb is like judges are satisfied with your argument. I'm saying you just conclude it and then the question will be put.
Ma'am, could you repeat what you said? It was not audible for me.
I have simply said one thing, that rather than saying if the judges are satisfied with my this limb of arguments, should I proceed? You please continue with your argument. Once you'll finish your argument, then we'll put the questions to you.
Much obliged, ma'am. moving on to the next issue, it is humbly submitted that the accused persons are liable to be punished under Section 25 and 27 of the Arms Act 1959. From the statements made by the prosecutrix as well as the eyewitnesses in the present case, it is clear that the accused persons were in possession of a prohibited firearm and used it for the commission of the offense of kidnapping and rape. The victim stated in her statement under Section 161 of the CRPC that while she was on her way to school, 4 accused persons kidnapped her at gunpoint on 2 motorbikes and took her to a vacant plot covered with dense bushes. Subsequently, the accused Rakesh Kumar pointed a gun at her forehead, after which the accused persons proceeded to rape the victim. Further, she stated that when the residents of the locality heard her screams, they approached the vacant plot, after which the accused person, Rakesh Kumar, fired a gunshot at the residents. Consequently, in the process of fleeing, the accused person, Rakesh Kumar, dropped the gun, which was then picked up by the accused Ajay Kumar, who tucked the weapon in his waist. This chain of events clearly establishes the possession and use of gun by the accused persons. Evidence of the use of prohibited weapon by the accused persons is the seizure of an empty cartridge case. Spent bullets and cartridge cases are much more likely to be found at the scene of the violent crime rather than at the crime scene than the gun itself. On 17 February 2022, the police arrested 3 accused persons, namely Anuj Kumar, Anil Kumar, and Ajay Kumar at around 10:30 a.m. During the search of the house, wherein the said accused persons were arrested, 1 country-made weapon katta, along with 5 live cartridges, which were of .315 bore, were seized in the presence of 2 independent witnesses, namely Hemant Kumar and Kundan Kumar. The seizure memo of the katta along with the live cartridges were prepared. Through the lab reports, we find out that the accused number 4, Ajay Kumar's fingerprints were found on the katta as well. The fingerprints of Ajay Kumar and the fingerprints found on the firearm were 97.68% similar. This proves that he was in direct possession of the firearm. Section 25 of the Arms Act states that whoever acquires or has in possession or carries any prohibited arms or prohibited ammunition in contravention of Section 7 shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. Desi kattas are illegally manufactured weapons that are often duplicates of branded pistols. In the case of Vinayak Subre Hegde versus State of Karnataka, the court held that prima facie case is made out when the fingerprint on the firearm matches the fingerprint collected by the police during the investigation. It is also to be noted that the ballistic report of the investigation, in this report, firing pin and breech face marks present on the exhibit empty cartridge case marked EC1 was similar to the firing pin and breech face marks present on test cartridge cases. Hence, it is established that the gun so seized is the gun which was utilized to carry out this heinous crime on the 2nd of February 2022. The seizure of an empty cartridge, as well as the statements mentioning how Rakesh Kumar fired a gunshot at the witnesses, indicate the use of prohibited firearm, which is punishable under Section 27 of the Arms Act. In the case of Sonu versus State of Haryana, the court held that the country-made pistol, katta, recovered from the appellant was designed to discharge a projectile, and therefore, even though it may have fallen into despair, nonetheless falls within the definition of a firearm within the meaning of Section 2E of the Arms Act. In the present case, judges, it is to be noted that this katta was in fully functional conditions. Further, the court observed that the possession of ammunition is punishable offense under Section 25 of the Arms Act. The use of such ammunition is punishable under Section 27 of the Arms Act. Your Lordships, with that, I would like to conclude the arguments under the issues of charges under IPC as well as Arms Act. My co-counsel will be dealing with charges under the JJ Act as well as the POCSO Act.
Counsel will be arguing issue 2, which is whether the accused is guilty under sections 6 and 8 of the Protection of Children from Sexual Offences Act 2012. Respected judges, the present case is a heartbreaking crime that causes one's mind to rage. A young girl of 15 was brutally gang raped by the 4 accused while she lied there helpless and screaming for help. Counsel will be presenting the arguments on this particular issue in 2 limbs. The first one tackles a charge of Section 6 of POCSO Act, which prescribes a punishment for aggravated penetrative sexual assault. And the second limb will be the charge of Section 8, which is the punishment for sexual assault under POCSO Act. Moving on to the first limb. The accused are guilty under Section 5G of the POCSO Act, which states that gang rape of a minor girl is aggravated penetrative sexual assault. The 4 accused should be convicted for the same under Section 6. Respected judges, firstly, it is to be noted that minors cannot give consent. The 4 accused kidnapped the prosecutrix on her way to school, very well knowing that she was a minor. They even belonged to the same neighborhood. Furthermore, Mr. Rakesh Kumar recognized her. Furthermore, the prosecutrix has given a detailed statement of the rape that happened to her. This statement was recorded. And as stated in the case of Barwada Boginbai Hirjibai versus State of Gujarat, mentioned in page 17 of the memorial, it is rare for a girl or a woman in India to make a false allegation of sexual assault. A girl or a woman in the tradition-bound, non-permissive society of India would be extremely reluctant to admit that any incident which is likely to reflect on her chastity had ever occurred. Furthermore, counsel pleads before the Honorable Court to take into account Section 29 of Protection of Children from Sexual Offences Act 2012, as mentioned in page 20 of the memorial. It essentially states that there is a presumption as to certain offences. Where a person is prosecuted for committing or abetting or attempting to commit any offence under Sections 3, 5, 7 and Section 9 of this Act, the Special Court shall presume that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is proved. In the present case, the accused has been charged under Sections 5G and Section 7 of the Act, which are provisions stated in Section 29. Thus, the burden of proof lies on the defence to prove otherwise. Respected judges, before moving forward with the arguments, counsel pleads before the Honourable Court to keep one thing in mind while contemplating this case. In the present case, the victim is a young girl in a conservative society. She will gain absolutely nothing from creating a false rape case. Her rape in the eyes of society tarnishes her image and deems her inferior, it deems her dirty. The same was stated in the case of Alam Khan versus State of Bihar, wherein Justice S.P. Khurdagar states, I find no reason as to why a child of tender age would implicate an innocent person for an offence which was undisputedly committed with her. The testimony of the prosecutrix clearly brings out the traumatic experience she suffered at the hands of the accused. Respected judges, the victim gains absolutely nothing if she concocts a case, and her statement is a cry for help. It is her belief in the justice system. This prosecution counsel pleads that the Honourable Court places Section 29 of the POCSO Act in high regard throughout the case. Moving on, it is common knowledge that in a lot of rape cases, it is generally difficult to find any corroborative witnesses except the victim herself. And therefore, the evidence of the victim is sufficient for conviction unless there exists compelling reasons for seeking corroboration. As stated earlier, the victim in the present case has given her statement. And as the learned bench already knows, this statement is of utmost importance. In the case of Vijay versus State of Madhya Pradesh, the court held that the statement of the prosecutrix is found to be worthy of credence and is reliable. Then it requires no corroboration whatsoever. The court may convict the accused on the sole testimony of the prosecutrix. Furthermore, respected judges, another point in this regard is that in the case of State of Punjab versus Gurmeet Singh, it was held that medical evidence can be of importance in such offences. However, its absence does not become fatal to the prosecution case. And the victim, if the victim has given a very clear statement of what has happened, then no corroboration is necessary. Thus, counsel humbly submits before the respective bench that the conviction of the accused can be on the sole statement of the prosecutrix. It does not even require a medical report. In the present case, the victim has given a very clear statement of what has happened, and it corroborates with the statement of the eyewitnesses even. Thus, it can be relied upon. In the present case, in addition to the statement of the prosecutrix, there does exist 4 eyewitnesses, namely Miss Kajal, Mr. Satyajit Kumar, Mr. Santosh Kumar, and Mr. Amit Kumar, who were neighbors of the prosecutrix, who ran to the area when the crime was being committed. After hearing the loud, agonizing screams of the prosecutrix, all 4 of these eyewitnesses have clearly stated that the victim was bleeding from her private parts, and this could only be a result of rape. And they even saw the 4 accused itself running away from the scene of crime. And one Mr. Rakesh Kumar even shot a bullet to scare the neighbors away. The events have been described in the exact same way by each of the eyewitnesses. This is direct evidence which corroborates with the details of the statement of the prosecutrix. To support this particular contention, counsel would like to state the case of Pratap Chauhan versus Ram Nayak, which has been mentioned in page 18 of the prosecution memorial, wherein it has been observed that if the statements provided by the eyewitnesses are consistent, natural, and are in consonance with other witnesses, then the statements can be taken into consideration and shall be held accountable. This particular stance has been held in various judgments. Furthermore, the Supreme Court recently observed in the case of Indresh Kumar versus State of Uttar Pradesh and another, mentioned in page 18 of the memorial, that statements made to police under section 161 of the CRPC may not be admissible in evidence, but are relevant for determining whether or not a prima facie case is made out against the accused. Counsel concludes this limb by stating a case which the prosecution counsel believes is of immense importance in the present case. This is a case of Abbas Hussain versus State of West Bengal, in which the Honorable Court observed that if the prosecution case is established by the evidence adduced, any failure or omission on the part of the investigating officer cannot render the prosecution doubtful. Your Lordships, pardon, your respected judges, if there exist discrepancies in the witness statements or the FIR, it is due to possible failure of the investigating officer. Furthermore, any omissions made by the investigating officer should not render the case of the prosecution itself doubtful, especially at this stage where the charges are being framed. Moving on to the second limb, which is Section 8 of POCSO Act that deals with punishment for sexual assault. Respected judges, sexual assault, as the respected bench already knows, is defined in Section 7 of the POCSO Act as whoever with sexual intent touches the vagina, penis, anus, or breast of the child or makes the child touch the vagina, penis, anus, or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration is said to commit sexual assault. In the present case, there exists a medico-legal report which can be submitted as expert evidence under Section 45 of the Indian Evidence Act, and it has mentions of abrasions on the breast, thus clearly indicating touching of the breast by the accused of physically handling the prosecutrix in such a way sexual in nature which caused the abrasions. Another point that the prosecution counsel humbly submits before the Honorable Court is that the medico-legal report mentions that there were no bite marks found on the body and no other marks besides the abrasions on the breast. But the prosecution counsel humbly submits that this does not mean that rape did not happen or that there was no sexual assault. In the present case, the prosecutrix was not in a position to put up any struggle after a certain point, as she was kidnapped by 4 persons. She was raped by 4 persons, 1 of whom had arms and 3 of whom were adults. Furthermore, as per the factual matrix, there were persons holding her hands and her feet in addition to the gun to her head to keep her from moving away or to keep her from attacking back too strongly as retaliation. She was clearly overpowered Thus, the absence of ghastly injuries on the person of the prosecutrix, as mentioned in the medical legal report, is not sufficient to discredit her evidence. She was a helpless victim then, she is a helpless victim now, and she needs justice. To support this particular contention, counsel would like to state the case of State of Uttar Pradesh versus Chote Lal, mentioned in page 19 of the prosecution memorial, wherein the court stated that it is wrong to assume that in all cases of intercourse with the woman against will or without consent, there would be some injury on the external or internal parts of the victim. Furthermore, to further strengthen this particular point, the prosecution would like to bring in the fact that there is an eyewitness here in the present case, namely Ms. Kajal, who was a neighbor of the prosecutrix, who saw the victim being physically and sexually abused from her position on the terrace. The same has been stated in the FIR. Counsel pleads before the Honorable Court to provide justice to this young girl who, for no fault of her own, underwent immense physical pain and psychological trauma under the hands of 4 brutal, cold-hearted persons. Counsel would like to conclude this issue by stating a case which the prosecution counsel believes is immensely important. In the case of Karnail Singh versus State of Madhya Pradesh, the Honorable Supreme Court observed, in cases of defective investigation, the court has to be circumspect in evaluating the evidence, but it would not be right in acquitting an accused person solely on account of the defect. To do so would tantamount to playing into the hands of the investigating officer if the investigation is designedly defective. Moving on to the next issue. Issue 3, respected judges, is whether accused should be tried as an adult. It is humbly submitted before the learned bench that the first accused, Rakesh Kumar, age 16, has committed a heinous offence and should be tried as an adult for the same. A heinous offence, as defined in section 233 of the Juvenile Justice Act, and which has been mentioned on page 20 of the memorial, basically entails offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is imprisonment for 7 years or more. In the present case, the accused are arrested under charges of kidnapping and gang rape of a minor girl, along with criminal conspiracy and use of arms, which falls under this requirement. Hence, the nature of offence committed is heinous. As stated in the case of Satya Narayan Tiwari and another versus State of Uttar Pradesh, mentioned in page 21 of the memorial, crimes against women are not ordinary crimes committed in a fit of anger of a property. They are social crimes. They disrupt the entire social fabric, and hence they call for harsh punishment. Furthermore, respected judges, according to section 15 read with section 18, the definitions of both is present in page 20 of the memorial. It essentially states that in cases of a heinous offence alleged to have been committed by a child who is 16 years or above, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offence, ability to understand the consequences of the offence, and the circumstance in which he allegedly committed the offence. Then the board may order transfer of the trial to the trial of the case to the Children's Court having jurisdiction to try such offences. Respected judges, as per the factual matrix as mentioned in page 12 of the proposition, the Honorable Board in the present case under Juvenile Justice Act 2015 did conduct an assessment of the accused Mr. Rakesh Kumar under section 15 of the Juvenile Justice Act and has already passed an order directing trial of the accused Mr. Rakesh Kumar as an adult under section 18 of the Act. Respected judges, this decision of the Honorable Juvenile Justice Board has possibly come after considering the fact that the minor has committed the offence of rape with a gun. He was the one holding the gun against the victim, preventing her from struggling too much or running away. It is sufficient to prove that the minor in the present case was having an intent to commit the crime and also was in a mental and physical capacity to understand the nature of the offence and the consequences thereafter. Thus, he should be tried as an adult. Furthermore, it is urged before this Honorable Court that to impose inadequate sentence due to sympathy for the minority of the accused would do more harm to the justice system, to undermine the public confidence in the efficacy of law, and society could not long endure under such serious threats. Respected judges, this particular contention was held in the case of State of Uttar Pradesh versus Satya alias Satyendra and others. It is therefore the duty of every court to award proper sentence having regard to the nature of the offence and the manner in which it was executed or committed. Counsel would like to conclude this issue by stating that the procedure in accordance with Section 23 of the Juvenile Justice Act states that at this stage it would be required that the case be transferred to the appropriate children's court and that he is to be tried as an adult as stated by the Honorable Juvenile Justice Board that conducted an assessment on him. Before moving on to the prayer, prosecution counsel humbly submits before the Honorable Bench one last point. The present stage, as the Honorable Bench already knows, is the stage of framing of charges wherein the nitty-gritty details are not of increasing importance as it would be in the trial stage. In the case of P. Vijayan versus State of Kerala, the Honorable Supreme Court held that at the stage of framing of charges, it is not necessary for the court to enter into the pros and cons of the matter or into weighing and balancing of evidence and probabilities, which is really the function of the court after the trial starts. Furthermore, in Stri Atyachar Virodhi Parishad's case, while considering the question of framing the charge, the Honorable Supreme Court held that while considering, the court has to see whether the material brought on record would reasonably connect the accused with the crime, and no more is required to be inquired into. The last case is the case of Yogesh alias Sachin Jagdish Joshi versus State of Maharashtra, wherein it was observed by the Honorable Supreme Court that the broad test to be applied is whether the materials on record, if unrebutted, make a conviction reasonably possible. Thus, respected judges, there might exist certain discrepancies. However, at the present stage of framing charges, if a prima facie case is observed, then the charges can be framed and chief and cross-examination of the witnesses, including the investigating officer and medical practitioners, as well as the accused, can be done during the stage of trial. Moving on to the prayer. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the counsel for prosecution humbly prays that the Honorable Court be pleased to adjudge, hold, and award conviction to the accused under Section 34, 120B, 363, and 376DA of the Indian Penal Code 1860, under Sections 6 and 8 of the Protection of Children from Sexual Offences Act 2012, and under Sections 25 and 27 of the Arms Act 1959. It was an honor arguing before this court.
Thank you.
Yes, sir. Justice Srivastava, would you like to put some questions?
Hello. I think Justice Sharma, what order should we maintain?
Whatever you say.
Right. I mean, you being the senior most.
No. There is no issue. Please, I was just asking if you want to ask a question or Justice Srivastava.
So the first question, I think the point which I would like this prosecution to address or you may note it down. You have paid very little attention to the stage of framing charges. The entire case is based on the law, on rape, on POCSO, on 34, on arms act. Whereas essentially the only thing was that at what stage are we arguing? And even in your prayer clause, you have asked for the conviction, etc., whereas this is the stage for the framing of charges. And my other 2-3 points are that there are vital discrepancies in the statement of 161 and 164. 161, the government said that the co-person kidnapped her. Whereas in 164, he had said that Rakesh had taken her and then he had taken her to a street where there 3 persons were there. So as per 164, the rape was committed in the street itself, whereas in 164, it is at a park. Another very major thing, I think, is MLC, which we have also referred to. We are relying upon the MLC for the abbreviations on the bill. But you please note that MLC nowhere mentions about the bleeding. It doesn't even touch There is no reference of bleeding. There is no reference of bleeding even on the clothes of the prostitute. And one thing more, I think, we totally missed out. It's about the board section 15 has conducted and has handed over the report, but the prosecution case does not make any reference about section 19, where the children's court has to decide about the finding of the board. It is not the board finding of the finding, but the children will finally have to decide as to how should the child decide it. In this new problem, I could not find that section 19 where finality of the board of probation of the given by the children's court. And there was too much emphasis on consent. She is a 15-year-old girl. She is not, the consent has to be consumed. But in this case, there is no requirement because apparently from 1 to A to Z. It's a case because there is no consent of the court for all those things. That there was no need to say that because of being a minor, consent is to be consumed. I mean, it's not that case. I think the best thing for which I won't find an answer is why would they falsely impute it? That's an argument which otherwise this prosecution case has many difficulties. But why these boys have been falsely implicated, yet that's not there. Maybe that comes later.
Ma'am, your voice is cracking a little bit, so I couldn't hear some of the points you put. I heard the last point you said, but
okay, that's okay. I think others will ask. So only the thing which you could heard.
Ma'am, would you want me to address this during the rebuttals or right now?
Rebuttals. At the time of rebuttals.
All right. Thanks.
Yes, sir. Justice Srivastava, would you like to ask something?
Yes, sir. I would like to mention here that argument was so good, but there is a question on my part that why the word prosecutrix is used in the case of a case under POCSO Act where the girl is victim. She is not prosecutrix. She is not adult lady. The argument is delivered on the line and pattern of a case committed with an adult lady. The word prosecutrix is not here proper. Secondly, when you are arguing about section 29 of the POCSO Act, then must argue in assistance with the section 30 of the POCSO Act itself, because there is a reverse burden of proof on the accused persons to rebut their presumption when the entire statement under section 164 given by the victim girl was corroborated with material evidence of the eyewitnesses, of the medical evidences, forensics experts' evidences, documentary evidences. As such, there was a strong presumption against the accused persons. They have to rebut. We have to hear about the defenses, but so far as my view at this level is concerned, there is a strong presumption against the accused persons which have been pressed, and vehemence should have also been given on this also, so as to fortify the case. That's all.
Indeed, sir. Thank you.
I think Ms. Kalra and Justice Srivastava has given all the points.
Thank you.
Both of you have presented your case well. So we'll see. Let's hear the defense and then.
Okay.
Please, I think you can read.
There is
counsel is permission to approach the dais.
Yes, please.
Much obliged, Your Honor. Good morning to the Honorable Bench. The counsel is appearing before the Honorable Court in the matter of State versus Rakesh Kumar and others on the behalf of the defendant. Your Honor, if Your Honor are well versed with the facts, the counsel now seeks permission to plead with the case. Your Honor, there are four main issues involved in the present case. First, whether the accused are liable under Section 34, 120B, 361, 363, and 376 DA of Indian Penal Code 1860. Second, whether the accused are liable under Section 6 and 8 of POCSO Act 2012. Third, whether the accused are liable under Section 25 and 27 of the Arms Act 1959. And fourth, whether the accused number 1, who is of 60-year-old, can be considered as an adult under Section 18 of the Juvenile Justice Act 2018. Your Honor, the first issue is whether the accused are liable under Section 34, 120B, 361, 363, and 376 DA of Indian Penal Code. It is humbly submitted before the Honorable Court that the defendants, namely Rakesh, Anuj, Anil, and Ajay, shall not be liable under the charge section due to change of statement by the victim recorded under Section 161 of CRPC and 164 of CRPC. Under 161 of CRPC, that is on page number 17 of the memorial, the prosecutrix tells that all the accused kidnapped her on gunpoint while she was on the way for the school and took her to the vacant plot and thereby raped her. Whilst under Section 164 CRPC, that is on page number 34, which states that accused number 1, that is Rakesh Kumar, forced her to go to the vacant plot along with him where all others were standing. Therefore, the accused are not liable because the sole evidence from the prosecution side is that the hymen is drawn, but it does not constitute rape. So it is humbly submitted that hymen is not a conclusive part to prove sexual assault. The hymen is a small membraneous tissue outside of the vaginal canal that has no known biological function. However, studies have shown that physical evidence of penetration is generally lacking in most reported cases of initial consensual or non-consensual sexual intercourse, even among the pre-pubertal girls. In the case of State versus Lalit Ratawal, the Delhi High Court observed that an accusation of rape cannot be proved only by torn hymen of the victim. It will be highly irrelevant as the hymen can be torn due to several reasons. It was held that a torn hymen does not prove previous sexual intercourse. The Delhi High Court held in the case of Vimlesh and others versus State and another that the false allegation of rape have the potential to destroy the life and career of the accused. The accused in a false case of rape loses his honor, cannot face his family, and is stigmatized for life. And also, it is humbly submitted that it is mentioned in FIR, that is on page number 9 of the memorial, that the victim was sent to DDU hospital for medical examination by MLC number 62. But the MLC report produced by the prosecution is from a different hospital named Sanjay Gandhi Hospital, that is on page number 36 of the memorial. And that too here, the MLC report number given here is 153, which is different as mentioned in the FIR. It is also mentioned in the FIR that the vaginal swab was collected and was sent to forensic examination, but the prosecution has not produced any such forensic report. So from here, it becomes clear that my clients are falsely implicated in this case. In the case of Parvat Singh was the state of Madhya Pradesh, the court drew attention to the fact that the statement under Section 161 of CRPC is inadmissible in evidence and cannot be relied for conviction. The court said that after viewing the submission made and the cases referred, it can be seen that there is no evidence whatsoever, either direct or circumstantial or forensic, against the petitioner. Accordingly, the bail was granted to the petitioner. In the case of Rakesh Kumar versus State of Bihar, in the said case, when the statement of the victim was recorded under 164 of the CRPC, where she completely denied the story of gang rape and she had nowhere stated the name of the petitioner in her statement recorded under Section 164 of the CRPC. Rather, she stated that she had gone to see a temple along with the co-accused, and while they were standing near a tree, the local people caught them and pressurized the victim to lodge the false case. The court observed that subsequent statement of the victim and the informant do not appear to be reliable, particularly when it is otherwise not supported by medical evidence. Likewise, in the case of the present case, that is State versus Rakesh Kumar, the victim, Kumari Manisha, stated in section 161 CRPC, that is on page number 17 of the memorial, moot proposition, that while she was going to school, she was kidnapped by all the four accused, namely Rakesh, Anuj, Anil and Ajay, kidnapped her on gunpoint and took her to vacant plot on 2 motor vehicles. And section 164 of the CRPC on the page number 34 of moot proposition stated that accused number 1, that is Rakesh Kumar, forcefully took her to vacant street where all other 3 accused were standing. Confession to police is inadmissible as it is. The accused cannot be merely convicted on the basis of the statement they made to the police. Section 24 of the Indian Evidence Act says that confession caused by inducement, threat, or promise when irrelevant in criminal proceedings, where a confession made by an accused person is irrelevant in a criminal proceeding, if the making of the confession appears to the court to have been caused by an inducement, threat, or promise having reference to the charge against the accused person. The confession, section 25 of the Indian Evidence Act states that confession to police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offence. In the case of Ram Singh versus Central Bureau of Narcotics, the Supreme Court, in accordance with the above principle, observed that section 25 makes confessional statement of accused officer is inadmissible in evidence which cannot be brought on record by the prosecution to obtain conviction. In the instant case, the possibility that there may have been inducement or threat made to the accused by the police or the prosecution so as to make the accused falsely confess of the offence cannot be ignored. In this respect, the Supreme Court in the Ram Singh case further made the observation that a confession made by the accused is rendered irrelevant in criminal proceedings if the making of the confession appears to the court to have been caused by inducement, threat, or promise with reference to charge against the accused. Further, Section 26 of the Indian Evidence Act also provides that no confession made by any person whilst he is in custody of a police officer, unless it may be made in the immediate presence of a magistrate, shall be proved as against such person. In the present case, the confessional statement made by the accused were made in the sole custody of police officer during the investigation without any presence of a magistrate. Hence, there can be no reliability placed on such confessional statement. In the case of Kamal Kishore versus Delhi administration, the Delhi High Court ruled that the confession made while in custody is not to be proved against the accused as the provisions of the Section 25 and 26 do not permit it unless made before the magistrate. Thus, considering all the above-mentioned arguments, the defense would humbly pray to this honorable court to not to neglect the accused party's plea of justice, where they have been falsely implicated in such a case, which would not only injure their reputation, but smear their names in society for the entirety of their lives. The next issue is whether the accused are liable under Section 25 and 27 of the Arms Act 1959. It is humbly submitted before the Honorable Court that accused persons are not liable under Section 25 and 27 of the Arms Act 1959. The accused persons are falsely implicated in this case. The prosecution did not prove that the gun belonged to the accused, and also it didn't prove that the accused person used it. PW2 Kajal, in her statement under Section 161 of CRPC, said that accused number 1, that is Rakesh Kumar, was holding the gun and rest of them were trying to do inhuman act of outraging the modesty of the girl. from the PW2 and PW3 statement, they have told that Rakesh Kumar was just holding the gun and the other three accused were doing inhuman act on the girl. But the victim in her statement under section 161 and 164, that is on page number 70 and 30, told that Rakesh Kumar was pointing the gun on her forehead. Anand Kumar was holding her legs and also tried to tear her clothes. Anil Kumar was holding her hands and pressing her mouth. At the end of the paragraph, she again tells that Rakesh Kumar and Ajay Kumar were in course of raping her. But the witnesses PW2 and PW3 nowhere mentioned that Rakesh Kumar was in course of raping her. So it becomes clear from here that prosecutress is giving different statements and the other two witnesses, that is Kajal and Satyajit Kumar, are giving different statements. So it creates a reasonable doubt as to who exactly raped her and also as to whether Rakesh Kumar raped her or not, or he was just holding the gun. So this also creates a reasonable doubt as to what the prosecution is trying to prove, and this case is falsely implicated on accused person. Your Honor, if we see on page number 39 of the moot proposition, which is the ballistic report, they have not confirmed that, and it is just opined that exhibit 8mm empty cartridge case marked EC1 has been fired through same pistol. This creates a reasonable doubt on the prosecution side. In Vikramaditya case, Singh versus State of Bihar case, the appellant was armed with a country-made weapon. The prosecution has been unable to prove that the said appellant has used the same. It is highly improbable that the appellant would have restrained himself from using the lethal weapon which was in possession. The prosecution has not been able to prove beyond all reasonable doubt the role attributed to the appellant, and he entitled to be given the benefit hereof. And also, it is important for the court to note that according to the prosecution story, and as per the eyewitness, it was Rakesh Kumar who was holding the gun. But when it fell down from Rakesh Kumar's hand, accused number 4, Ajay Kumar, just picked up the gun and kept in his waist. So if the prosecution statement was credible, then they should have tested both the accused person fingerprints. But here, they didn't even try to take the accused number 1, Rakesh Kumar's fingerprint, who was actually holding the gun for so long as per the prosecution. And also here, in the instant case, they have stated in the ballistic report, which is a report which just talks about the firearms, tells that accused number 4, Ajay Kumar fingerprints from the right hand have matched with the fingerprints present on the katta. But it has to be noted at the court, by the court, that there is no fingerprint report produced by the prosecution side to prove the same. This creates a reasonable doubt, and the prosecution side is just trying to falsely implicate the accused person in the instant case. In the case of Kishan Singh Parwana versus State of Chhattisgarh, here the accused was charged for murdering the deceased. He was convicted by the trial court on the basis of circumstantial evidence, mainly the positive opinion of fingerprints expert. Aggrieved thereby, the accused filed the present appeal. It was then noticed that the memo of the obtaining fingerprints of the accused did not carry the date or the signature of the accused or signature of the person who classified that and tested it. It was observed further that most importantly, if on the date of obtaining the impression, the accused was in judicial custody, the said impression could not have been obtained without an order from the magistrate. Thus, the document does not satisfy the test of legal and procedural sanctity in either of the terms. If on the said date the accused was in police custody, the document should carry the signature of witness as well as the accused, and if he was in judicial custody, there should have been permission from the concerned magistrate. Since it is not proved by the admitted fingerprints said to be of the accused were obtained from him while he was in custody, the report of the fingerprints expert is not such evidence which can be relied upon as one of the circumstances in the chain of the circumstantial evidence to establish the guilt of the accused. Similarly, latches were noted in other evidence as well, and it was held that the prosecution had failed to knit together the chain of circumstantial evidence so as to lead to only one conclusion, that is the guilt of the accused. Accordingly, the appeal was allowed and the conviction of the accused was set aside. It is humbly submitted before the Honorable Court that the accused person should not be held guilty on the ground of inconsistencies and discrepancies present in the case, which implies that the case may be a false implication against the accused. In the view of the above, the prosecution has miserably failed to establish the charges levied against the accused, and there was no evidence on record that linked accused appellant to the alleged charges. It was observed that the prosecution case suffered from severe contradictions and thus benefit of doubt could be granted to the accused. My co-counsel would be dealing with the second and the fourth issue.
The next issue before our honor is whether the accused can be made liable under section 6 and 8 of the POCSO Act 2012. So, it is humbly submitted before the Honorable Court that the accused are not guilty of the offences under section 6 and 8 of the POCSO Act 2012. In the matter at hand, it has been wrongfully alleged that the accused persons have committed rape on the minor girl. It is humbly submitted that the prosecution side produced only the circumstantial evidences in order to prove their case. The medical legal report of the prosecutrix fails to firmly establish that the allegations made on the accused are true, as there is no strong evidence to show that the accused committed sexual assault and rape on the prosecutrix, that is, discovery of semen stains, pubic hair, etc. on the victim's body or clothes. There is also no history of physical torture on the prosecutrix according to the medical legal report. The prosecution contended that there was penetrative sexual assault, but there is no evidence to prove that there was penetrative sexual assault. Even the witnesses have never said in the statements that there was penetrative sexual assault. The prosecution only mentioned that the victim was bleeding from her private part and her hymen was torn. It is to be noted that the clothes of the victim was not medically examined, which actually creates a reasonable doubt from the prosecution side. One of the contention by the prosecution side is that the hymen is torn, which means that rape was committed. But it is important to note that it's not always necessary that if hymen is torn, it means the rape was committed. It is true that injury is not a sine qua non for deciding whether rape has been committed, but it has to be decided on the factual matrix of each case. In the case of Pratap Mishra versus State of Odisha, there were allegations of rape by many persons and several times, but no injury was noticed. Presence of injury in this case certainly is an important factor if the prosecutor's version is credible, and then no corroboration would be necessary. But if the prosecution's version is not credible, then there would be need for corroboration. Absence of injury on any part of the body of the victim girl sometimes tells that there was absence of coitus. In this case, the victim girl, who is the only witness as to the commission of rape on her, deposed to the effect that she struggled her best to get up from the ground where she was made to lie down. Her evidence to the above effect was not corroborated by anything else on the record. If she really had struggled that way for a long time, it was expected that she would have sustained numerous injuries on her back, buttocks, and other parts of the body. But according to medical records, no such injury was found on her body. It sounds improbable that a girl of 11 to 12 years was reportedly raped by the accused at a rough and rugged place near the railway lines for a long time, and she was struggling hard to extricate herself from the clutches of the accused, but she did not sustain any injury indicating any struggle. The lady doctor who examined the girl only found that the vagina was inflamed and her hymen was torn, and there was some bleeding from that injury. The lady doctor did not find in the vaginal discharge of the girl any live or dead spermatozoa. From the evidence of the doctor, it could not be definitely stated that the injury on the private parts of the girl was due to the alleged act of rape by the accused and not due to any other possible cause. Thus, sexual intercourse itself was not proved and the accused was acquitted. In another case, that is in Thakaria versus Rajasthan, in this case, there was no injury in the vagina, but there was fresh tear of hymen. The victim stated that the accused forcibly inserted his male organ in her vagina. She further stated that the appellant indulged with her in the act for some time. There was no doubt she did not receive injuries in vagina. No semen was found on her person. The swab which was taken from vagina was negative for semen, and no injury was found on the penis of the appellant. However, the statement of the victim was not negative as to the penetration by any of the aforesaid circumstances. There was nothing to disbelieve that penetration was effected, and this fact was corroborated by the tear caused to the hymen. No doubt, hymen can be torn for a variety of reasons, but the question was whether the statement of the victim in the circumstances of the case could be held to be reliable. The presence of fresh tear of hymen corroborated the statement of the victim, and also there was no injury caused to her vagina or labias. Only some superficial abrasions were noticed on back of the victim. It was held that she was not subjected to rape and acquittal was proper. When the sex organ of the accused is fully developed and normal, and the prosecution case is one of complete sexual intercourse, absence of injury on private parts of the girl militates the story of sexual intercourse. In one more case, that is in Dilip and another versus state of Madhya Pradesh, Mohan and Dilip were two accused appellants, and they have been guilty of an offence punishable under section 376 clause 2 clause G of the IPC by Session Judge of Madhya Pradesh. Their appeal was dismissed by the High Court maintaining the conviction. So they filed an appeal in the Supreme Court by special leave petition. In this case, it was told by the court that the age of the prosecutrix was around 16 years, maybe a little more. The fact remains that she was not just a child who would have surrendered herself to a forced sexual assault without offering any resistance whatsoever. Without going into testing truthfulness of the explanation offered by the prosecutrix that because of being overawed by the two accused persons, she was not able to resist, the fact remains that the probabilities factor operates against the prosecutrix. The gang rape is alleged to have been committed at about 2 p.m. in her own house, situated in a very populated village by the side of the main road where people were moving on account of Holi festival. The court here found it difficult to accept the truthfulness of the version of the prosecutrix that any sexual assault as alleged was committed on her in view of the fact that her narration of the incident becomes basically infirm on account of being contradicted by the statement of her own aunt and medical evidence and the report of forensic science laboratory. The defense has given suggestions in cross-examination for false implication of the accused persons, which however has not gone beyond being suggestions merely. The court was not satisfied generally of the correctness of the story as told by the prosecutrix. They found it difficult to hold the prosecutrix in the case as one on whose testimony an implicit reliance can be placed. For the foregoing reasons, the appeals were allowed. The conviction of accused appellants as recorded by the trial court and upheld by the High Court was set aside, and the accused appellants were acquitted of the charges framed against them. So, it is humbly submitted before the Honorable Court that the prosecution has failed to pinpoint as to whether rape was committed on the victim minor girl or not. Also, it is important to note that the entire case rests solely upon the uncorroborated circumstantial evidence. Therefore, it is humbly submitted before this Honorable Court that the charges under the Rape and POCSO Act against the accused cannot be made in the present matter. Now, the counsel is moving to the fourth issue. So, the fourth issue is whether the accused number 1, who is about 16 years of old, whether he can be tried as an adult under Section 18 Clause 3 of the Juvenile Justice Act 2015. It is humbly submitted before the Honorable Court that the minor accused cannot be tried as an adult. The accused persons, including the minor, are innocent and they are falsely being implicated in this case. The victim girl herself had made two conflicting statements which actually proves that the prosecution's case is not valid and the accused are falsely being implicated here. The victim girl, while giving her statements to the police under Section 161 of CRPC, tells that when she was going to school, she was kidnapped by all the 4 accused persons on the gunpoint on 2 motorbikes, and then they took her to the vacant plot. But while making her statements before the Metropolitan Magistrate under Section 164 of CRPC, she gives conflicting statements. Here, she tells that while she was going to school, Rakesh Kumar, who was staying near her house, he alone kidnapped her and took her to a vacant street where the other 3 persons were standing. Here, in this statement, there is no mention of bikes. So, I submitted before this court that the accused are falsely being implicated in this case. The Supreme Court, in the case of Radhu versus State of Madhya Pradesh, alerted trial courts about the rising incidence of frame-ups in rape cases on the basis of false testimony. In this case, the accused was found not guilty and acquitted on the ground that the medical evidence did not sufficiently establish that sexual assault was perpetrated upon the victim. In Sunil and Another versus State of Haryana case, while dealing with an appeal in a gang rape matter, the Punjab and Haryana High Court has held that undoubtedly the statements given by the victim prosecutrix under oath during her examination before the trial court has great sanctity, but her statements recorded under Section 161 and Section 164 CRPC could be used by the defense counsel for the purpose of contradiction. In one more case, that is in Sonu Yadav versus State of UP, here in this case, the criminal appeal has been filed by the accused convicted under Section 302 of IPC. The learned counsel for the appellant submitted that the appellant is innocent and has been falsely implicated in this case. It was submitted on behalf of the appellant that the occurrence is alleged to have taken place on 28/2018 and he was not named in FIR. The informant in his statement under Section 161 of CRPC recorded and admitted that occurrence was committed in the night by unknown person and no one has seen the alleged offense. The inquest and post-mortem also took place on the very same day. The cause of death in the post-mortem report was shock and hemorrhage due to ante-mortem injuries. The statement of eyewitness Guru Prasad, who recorded where he stated that the deceased had consumed liquor and unknown persons have murdered him. None of the prosecution witnesses has taken the name of the appellant. In the restatement of the informant, which was given after about 2.5 years later, the name of the appellant has surfaced and a new story has been developed that one person told him that on the date of occurrence, the appellant along with the co-accused persons was seen returning from the place of occurrence and they were holding danda and axe in their hands. It was contended that there is no direct or circumstantial evidence. The informant himself in his restatement has not given lasting evidence. There was no recovery at the point. The appellant had no criminal history. The informant has changed his statement in his restatement after 2.5 years, which makes his testimony untrustworthy. In fact, there was no investigation conducted by the police. Considering the facts and circumstances of the case and also the fact that the appellant is in jail since then, having no criminal history, without commenting upon merit of the case, the judge was of the view that the learned court below had failed to appropriate the material available on record. In view of the above, the order of rejection of bail passed by the court below was hereby set aside. Accordingly, the appeal was allowed. So, finally, it is submitted that the present case is falsely being implicated as there are conflicting statements being made by the minor accused under Section 161 and 164 of CRPC. And also, it is humbly submitted that the confession made by the accused minor is not admissible before the court. In Vikas Sangwan versus State, the Delhi High Court ruled that taking the confession from a child regarding the way the crime was committed is beyond the scope of preliminary assessment report prepared under Section 15 of the Juvenile Justice Act, and it is unconstitutional. The division bench comprising of Justice Mukta Gupta and Anish Dayal stated that such a confession taken from a child by a psychologist should not be encouraged. Section 15 of the Juvenile Justice Act provides that a child between the ages of 16 to 18 can be tried as an adult if he or she has committed a heinous offense. This provision has drawn a line to classify juvenile delinquents in 2 categories. One is below the age of 16 and the other is above this age. The Juvenile Justice Board, before passing its decision, has to strictly conduct a primary assessment of the juvenile's mental and physical capacity to commit such an offense, to understand the result of the offense committed and the situations under which he committed the crime. The court here said that under Clause 3 of the said report, it can be clearly noted that a confession is sought to be extracted from the child as to the manner in which the offense was committed and the reasons thereof. This manner of seeking a confession from the child is unconstitutional and beyond the scope of report of preliminary assessment to be prepared under Section 15 of the Juvenile Justice Act. The Council for Intervenor Hutt Center for Child Rights told the court that the preliminary assessment report of child in conflict in law was prepared by a psychologist. The report submitted discloses that the confession of the child was made against its constitutional right. Hence, it was totally uncompromised. The observation was made by the court in the present case with respect to the directions issued by the JJ board for the way of preliminary assessment in case of grave offences committed by juveniles. Further, it was argued that the investigation and psychological assessment done was such in nature that even an adult cannot be forced to answer under the law when faced with allegations of the commission of such grave offences. It was further contended that through the psychological examination or inquiry, the child was being asked questions that even an adult cannot be compelled to answer under the law when faced with such allegations of the commission of such a heinous offense. The court noted the same in its order. The guidelines issued by the Apex Court regarding the report of preliminary assessment in Barun Chandra Thakur versus Master Bolu and another, the court found that even the questionnaire in relation of the social investigation report prepared for children in conflict in law under Section 8 of the JJ Act was not correctly interpreted, since a presumption is raised at the early age of the trial proceedings that the child committed the crime. In Saurabh Jalendar Nangre versus State of Maharashtra, a single bench allowed a petition challenging the Juvenile Justice Board committing a child who has not committed the heinous offense to the Children's Court. In the present case, petitioners concerned were not adults when they had attempted to commit an offense of such heinous crime. They all were aged 17 years at the time of the commission of the offense and were admittedly falling under the definition of Section 2 Clause 12 of the Juvenile Justice Act 2000. The petitioners were referred to a psychologist for assessment, and on placing the report of the same before the JJ board, the assessment made by the board was that the mental as well as physical capacity of child in conflict in law was sufficient to commit crime. Therefore, the JJ board transferred the matter to the Children's Court in accordance with Section 18 Clause 3 of the Act. This order was challenged by the petitioners before the High Court. The learned counsel for the petitioners, Mr. Satyarath Joshi, stated the petitioner being child, if not have committed a heinous crime, then they are to be tried by JJ board and not by the Children's Court. The court considered Section 2 Clause 33, which defines heinous crime, and noted to be one which is punishable with a minimum imprisonment of 7 years or more. However, under Section 307 of IPC, no minimum sentence is prescribed. Therefore, the court of the opinion that since the offence alleged to have been committed by the petitioners was a serious offence and not heinous offence, Section 15, under which assessment into a heinous offence was to be made by the board, had no application. In the present case, on the basis of the discussion and as mentioned above, the court held that the board could not have transferred the case to the Children's Court. Hence, the impugned order was quashed. The board was directed to proceed with the inquiry. So, it is humbly submitted that this manner of seeking a confession from the child is unconstitutional and beyond the scope of a report of preliminary assessment to be prepared under Section 15 of the Juvenile Justice Act. And also, it is humbly submitted that the juvenile who has been the accused in the present case should not be tried as an adult in the present case, as the case has been falsely being implicated. So, it is humbly submitted that the prosecution failed to prove the guilt beyond reasonable doubts. The counsel would now seek the permission to move to the prayer. Indeed, Meenakshi. Wherefore, in light of the issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to acquit Mr. Rakesh Kumar, Anuj Kumar, Anil Kumar, and Ajay Kumar for not committing the offence of kidnapping under Section 363 and not committing an offence of gang rape on women under 16 years of age under Section 376D of IPC 1860, and for not committing the offence of aggravated penetrative sexual assault under Section 6 and 8 of the POCSO Act 2012, and acquit them from the offences under Section 25 and 27 of the Arms Act 1959, and or pass any other order it may deem fit in the interest of justice, equity, and good conscience. It was pleasure arguing before this court.
Your Lordships, pardon, respected judges, can prosecution counsel proceed with rebuttals, or will that come at a later?
Yes, Sharma, I would like to have some points to the prosecution, defense counsels also. My point again is that the important point is at what state are you arguing? This is the state of writing of charges. So again, that was totally missing from the argument as to at what state you are arguing. And there is a lot of emphasis on confession, whereas in the problem which has been shared, there is only one reference that the accused confessed. Otherwise, confession is technically under section 164 CRPC, which is not there. So then, out of proportion emphasis on confession, I think it was not required because only a reference they confessed. And it's also not part of the prosecution story as to why this should have been implicated, why there was a whole implication. And again, I think you have touched upon that children's court, that is good. You have touched upon the board report, because that's an important thing. But I could not find from your argument that the report of the children's court is missing. So as far as the report of board is concerned, that is incomplete until it is being endorsed by the children's court under section 19. And you argued it very, because I found it was more on the practical side, more rather than theoretical, it was more practical. It looked like in the court. Not too much emphasis on law. Basically, first one has to show as to whether the facts constitute an offense. So that is more important rather than more of the law. Thank you. Yeah.
Yes, Justice Srivastava, would you like to make some remark, or can we go for rebuttal?
Yes, sir. I would like to make some points here after hearing the defense counsels. Actually, the defense is heavily based on the hyper-technical view of the medical legal evidences, forensic evidences, etc. But these are the secondary things. First of all, the eyewitness, the direct witnesses, and even the injured witness, that is victim, who stands on the pedestal of injured witness, whose reliability and credibility is undoubted. How can be impeached, on what circumstances, in fact, they have carved out from the chief examination and after cross-examination, what comes out to disbelieve or discard or impeach the direct witnesses regarding the presence on the spot. When the story starts with the seeing the direct witnesses, the 4 accused persons sexually abusing the victim. This part was how impeached, how not witnesses are not credible. Unless these things are set forth by the defense counsel, the evidence of the prosecution should not have been disbelieved. Secondly, agreeing on the point that confessional statement have no value, evidentiary value, but there is one thing to be discriminated. All the confessions recorded by the police authorities were self-inculpatory also, not self-exculpatory. The difference is the self-inculpatory and self-exculpatory, that the police authorities may be imputed with some charges of promising or giving some benefit to particular accused of getting rid of the prosecution if they fasten the other people, but all the 4 have confessed equally with self-inculpatory expression, have given this themselves. And this part of the statement of confession, this even we discord their presence was found and seen by the direct witnesses on the spot. As such, first of all, the things established by the evidence of prosecution and defense both, that all the 4 accused were present there. For example, the victim, when cross-examined by the defense counsel, should have been given the suggestion or question as to enmity or as to other things for making false allegation against him, but any such thing is not on record. Plainly, they have denied. Simply denied from their presence is not enough. This part of the argument is lacking in the defense argument. Otherwise, so far as the medical legal evidence is concerned, this is a scientific phenomena. Each and every traumatic position puts impression on persons differently according to their level of age, level of health, level of understanding. Therefore, this cannot be taken as a full certainty. This is to be discarded as against the direct evidences. Therefore, the vehemence put on the hypotechnicality of the evidences, medical legal evidences, is not enough for argument. Thirdly, in making the argument in defense, the defense is overburdened not only to put the academic discussions over the evidences, but all the evidences and case laws have pertinence with the fact itself. If they are not pertaining to the fact, some of the rulings were preferred in accordance with the law as it was then, when 375 of the IPC was not amended. POCSO Act has not been come in light. The 375 has itself amended so vehemently that any part of the body, if penetrated in the vagina, that is, founds the constitute the offense of rape in view of the POCSO Act. The case is running under POCSO Act, and this special act is to be given preference and the time of argument, how they come out from the charges fastened against them. That's all.
Thank you, sir. I think we can first hear rebuttal. Then I'll make remarks.
Yeah, future laws they should keep in their mind.
Yes, if the court permits, the teams will proceed with the rebuttal rounds. Yes.
Okay.
Much obliged. With respect to certain points that the Learned Defense Counsel has stated regarding the Arms Act, first of all, it was the Learned Defense Counsel stated that the gun was not in possession of Ajay Kumar, and the only question that the prosecution counsel has is on what basis is that statement being said, because there were 2 independent witnesses at the time of possession, at the time of the police taking the gun from Ajay Kumar, and there are also his fingerprints on the same. Secondly, it was stated that it is questionable that Mr. Rakesh Kumar's fingerprints are not there on the gun. It is often difficult to obtain fingerprints from some surfaces, especially firearms. The ability to lift fingerprints from a surface is really based on the type of surface. It's much easier to lift fingerprints from smooth surfaces like glass or tile, and the process gets more difficult when it comes to painted surfaces, and it becomes more difficult when there are textured surfaces such as checkered handgun grips. Lifting fingerprints from guns and firearms, especially ones used in crimes, is extremely difficult because it's oily, it's extremely dirty surfaces, there are multiple overlapping impressions. The fact that the prosecution can't present fingerprint evidence doesn't mean that the case isn't strong. The prosecution can meet its burden of proof of guilt beyond a reasonable doubt with direct and circumstantial evidence. The Learned Defense Counsel has completely ignored the fact that the prosecutrix and the eyewitnesses did state that Rakesh Kumar was holding the gun and did shoot the gun. That using of the firearm has not been talked about by the Learned Defense Counsel. Furthermore, another point that the Learned Defense Counsel hasn't stated is, why was the accused there at that point of time? Why were the 4 accused there at that point of time? And another discrepancy that the prosecution counsel would like to address is, as ma'am stated from the learned bench and as the Learned Defense Counsel stated, there is a discrepancy in the victim statement of 164 and 161 regarding the kidnapping. However, as prosecution counsel stated in the arguments, certain discrepancies in the investigation cannot render the prosecution's case itself doubtful. Considering the fact that the victim was in a state of immense mental trauma while reliving these memories and stating it, she must have had a lot of difficulty in exactly stating what happened at what point of time. However, the key point in the statement of 164 and 161 is that, regarding kidnapping, is that she was forcefully taken. The word forcefully has been used. So there does exist that element of kidnapping. There has been a lot of mental trauma for the victim as a young girl being gang raped by 4 persons, and thus speaking about it might have been extremely difficult, which possibly could have caused the discrepancies. Furthermore, another point that the prosecution counsel wishes to address is that the Learned Defense Counsel stated that the witness statement of the second witness and the third witness, that is Ms. Kajal and Mr. Satyajit Kumar, is contradictory to that of the prosecutrix solely because of the difference in the words used. Prosecution counsel humbly submits before the Honorable Court that the difference in the words used does not mean that the act itself that happened was the same. It is not necessary that word to word, every word said by the by the victim and by the witnesses will be the same. Furthermore, once again, the prosecution counsel humbly submits before the court that there have been certain discrepancies that have been done and certain omissions that have been committed by the investigating officer. But as stated in the cases of Abbas Hussain versus State of West Bengal and Karnail Singh versus State of Madhya Pradesh, this does not render the case of the prosecution itself doubtful, especially at this stage where the charges are being framed. Nothing further.
Thank you.
Ms. Vajpayee, will the defense will also be making statement in the revision?
Indeed, my lord. Indeed, Your Honor.
Okay.
So, the prosecution at the beginning mentioned that all the 4 persons kidnapped her while she was going to school. But the minor girl, while recording her statement before the magistrate, she is giving a different statement. So, which statement has to be taken into consideration? Like, what should we take into consideration? The prosecution statement or the prosecutor's, which is said under section 164 of CRPC? Because section 164 of CRPC should be given more importance than section 161 of the CRPC. And the prosecution side said that the fingerprints of the accused number 4, Ajay Kumar, matched by 97.68%. But the prosecution hasn't produced any fingerprint report. Then there is a doubt as to whose fingerprints were collected and exactly with whose fingerprint it was matched. Without a fingerprint final report, nothing can be proved. The absence of fingerprint final report creates a reasonable doubt and matching of the fingerprints. And also at last, the prosecution side mentioned that it is very much difficult for the forensics to collect the fingerprints from the surfaces. But it is if it is so much difficult, then how can the ballistic report say that it is matching by 97.68%? And also the prosecution stated that the prosecutrix was brutally gang raped. In the beginning, the prosecutor stated this, but there is no evidence to prove the same. Even the MLC report does not tell anything about the same. On page number 9 of the mode proposition, in the 4th paragraph, it has been mentioned that the vaginal swab was collected in the hospital and was sent for forensic examination. But till now, the prosecution has not produced any such forensic report. Forensic report would have made the case very clear, but the prosecution is reluctant to produce the same in this case. This actually creates a reasonable doubt on the prosecution story. And the prosecution mentioned that it is a minor discrepancy. It is humbly submitted that this is not a minor discrepancy. The victim was produced before the magistrate after around 8 days. This actually is also a problem. Like after 8 days, why after 8 days? Your Honor, please see page number 31 of the mode proposition. According to this, the FIR was registered on 2nd February 2022, but the statement was under section 164 was recorded on 10th of February 2022. Now, it is a question how the girl can change her statement so easily. So, it is humbly submitted that these should not be considered as minor discrepancies, and so it is humbly submitted before the court that the prosecution should prove the charges against the accused without any reasonable doubts and discrepancies. So the accused should be given the benefit of reasonable doubt and they should be acquitted. That's all mine.
Respected bench, if I might just state one point.
Yes.
Just one point. The Learned Defense Counsel stated that the medico-legal report is not sufficient to state that there was penetrative aggravated sexual assault. At this point of framing charges, as stated in the cases that counsel had mentioned earlier, the sole testimony of the prosecutrix is sufficient. So,
That's
counsel
correct.
will just...
You've already said.
Okay, much obliged.
So,
one more point, Your Honor. One more point. In the FIR, it is mentioned that the victim was medically examined wide MLC number 62 of 2020 dated on 2nd February 2012 on the page number 9, Your Honor. There it was mentioned that she was medically examined in DDO hospital and MLC number was 62 of 2022. But on page number 35 of the mode proposition, the prosecution which they are producing the medical report, it is from a different hospital. That is from Sanjay Gandhi Hospital, Mangolpuri. And here it is not proving that any sexual assault was committed or something.
Okay. So, before I make my remarks, can I take break for 2 minutes? I'll just join in too.
Sure, sir. Definitely, sir. I think there is some issue with the sir's internet connection over there. Teams, have you concluded your rebuttal round?
Yes, ma'am.
Okay, so we are just waiting for the feedback from the judges and then we'll proceed for vote of thanks.
Thank you.
Yes, sir, I'm waiting for Dinesh ji. I think Dinesh sir is joining. He has joined. I think there is some net connectivity issue with his device. So let us just wait for 1 minute. I think he will connect again. Meanwhile, ma'am, you may question the teams if you wish so. Yes. The other judges, you may question the teams if you wish so.
So that's enough.
Ma'am, you may question if you want to.
No, my point is because Justice Sharma said that he'll be making the concluding remarks. So otherwise, we have made the remarks. Yeah. In the meanwhile, if the participants have anything they can ask while we are waiting for Justice Sharma. Yeah.
Yes, sir has joined. Yes, sir. You are waiting for your remarks.
So, to begin with, I must.
Sir, you're on mute, sir. We are unable to hear you.
Oh, I'm so sorry. I'm so sorry. So I'll repeat myself. First of all, I must compliment and congratulate to all the participants, speakers, researchers for the wonderful presentation you have made. Kudos to all of you. You really done worked very hard and was very clear from the presentation. But there are certain remarks which I would like to make. Though my colleague judges have already pointed out, made certain observations which are very, very important and very important. Besides this, certain things which I noted and I think that I must convey to the learned council. First of all of you were at one point or the other possibly was not very clear about the stage at which you were asking. And some of you said be acquitted, somebody said be convicted, somebody said not proved beyond reasonable doubt. So the first thing which you must, whenever you argue at any point, any law, any thing before the court, you must first emphasize on the basic reasons. Like here, you were arguing at the point of charge. But sadly, none of you even referred to Section 227 and 228, which are the basic reasons for framing of the charge by the Sessions Court. So what are the requirements of the framing of the charge? So first, either prosecution is arguing or the defense is arguing, you must start with that what is the jurisdiction of it? What are the factors which have to be taken into? Second, when you argue, your facts must be very simple. You were talking about facts, but suppose prosecution is relying on the statement of the prosecutor. It is always desirable, it is always better if you refer to the statement of the complainant. You read that. If you are saying that defense is saying that there are discrepancies, just merely saying it will never be that effective. If you actually read that the X has stated this in his statement, Y has stated this in his statement, that will actually highlight that. Unless you do that, the things will never be registered in the mind of you. You have actually to demonstrate that these are the contradictions. Or the prosecution has to demonstrate that these are the witnesses, my witnesses, these are the ingredients of the law, and these ingredients have been stated by the witnesses in their statement. Unless you do that, it will not be able to have effective representation. Thirdly, I do not know what are the rules in the moot court of the court. But whenever you cite the judgment, whenever you rely on the judgment, you must give the citation. Merely saying Shankar Singh versus Union of India, Ram Bahadur versus State of Punjab does not mean anything. Unless you give the citations that these are the citations or SLP number or where you can find it. Merely giving the names will not. So, and there should not be over-reliance on the judge. Whenever you argue, you have to marshal the facts first. Your facts should be strong. And either it's the prosecution or the defense, then you have to fit in those facts in the provisions of law. The basic flaw which is being done is that we don't go to the basic law, basic provisions of the law. As was rightly said by my brother Justice Srivastava, you go on, keep on citing the precedents, but every case has its own the peculiar facts and circumstances. And at the stage of charge, the stage of charge is a very nascent stage. Here you have only to show the prima facie case. So here your only requirement should be prosecution should be that this is the basic provision of law, this is the statement, so there is a prima facie. Defense that no, these are the discriminations, or there are certain doubts where they have said that there should be grave suspicion. Mere suspicion will not be sufficient to frame the charge. There has to be grave suspicion. The defense sadly did not even touch this point that the charges cannot be framed merely at the asking of the prosecution. And the basic judgment on the charge for full Samuel judgment is there. Where they have, Supreme Court has given 13, 14 benchmarks on which the charges are to be framed by the Sessions Court. So you have to cull out from the facts and then say, okay, no, these are the minor discrepancies, these are the major discrepancies, or it is making a case very doubtful, so there is no prima facie case. So instead of having an over-reliance on the judgment, you should more discuss the provisions of it. That will be better. So otherwise, all of them have argued very well, and it was a wonderful effort on part of you. And speaking for myself, I have really been impressed by your presentation. It was a very good effort. Yes, my brother judges insisted that for me. Right. Yes, Ms. Kadra and Justice Shiva.
Yeah. And to all the students who have taken this effort right at the stage when they're studying law, because ultimately law is learned in the courtrooms, and the classrooms don't make you a lawyer. So the courtroom makes you a lawyer, and this moot court, while you are studying law, is a real boost to your professionalism. And what is important in law is your wit, which I found was not that. You should be able to respond to the questions which were raised while the arguments are going on. You should have an answer to the questions which were raised during the course of arguments. And you really did well. And as Justice Sharma had also said, and I also mentioned about over-reliance on judgment after judgment after judgment doesn't make much of an impact, because ultimately the facts which have to stand the testimony of the law. And one thing yeah, it was good, and I must compliment you all, and you keep doing well. And even at this stage, I would like you all, those who are so good students, to be a good lawyers also. The litigation is the best field for when you study law, the litigation is the part which you must opt for rather than not doing litigation and something else. Judiciary is in furtherance of litigation, so go for litigation and aspire to become good lawyers. Thank you so much.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am. Sir Vikas ji, I request you to please motivate our students with by saying few lines so that our future lawyers can be as brilliant as the bench is today.
Much more has already been said by Justice Sharma, and I concurring with that, must add here that every participant of this moot court must have a bright future if he thinks about the facts and circumstances put before him for the arguments. Secondly, they must keep into their mind that the competition is not with any other body. They are competing with themselves so as to improve them or further presentation of the cases in such better and good manner that shall guarantee a win in between them. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you, ma'am. I would now request Mr. Sanjay Poddarji to kindly join and take over through virtual mic for vote of thanks.
Good morning to everyone. I, on behalf of Adhivaka Parishad, Delhi High Court Unit, thank all our honorable judges Honorable Justice D.K. Sharma, Judge Delhi High Court, Honorable Mr. Justice V.K. Srivastav, retired Judge Delhi Allahabad High Court, and now presiding officer of CGIT, Madam Jyotika Kalra, advocate and former member of National Human Rights Commission, for accepting the invite for judging the semi-final round of third virtual criminal moot court competition. I also congratulate both the teams for participating and taking part in the competition. They have done excellent work and they have performed well according to the assessment made by our honorable judges. And both the teams have performed equally. And that is why it became difficult for us to select one of the team to reach final round. And I wish good luck to the winning team. And the winner is, who is the winner? Achha. So winner will be declared shortly. Thank you everyone, and thank you our honorable judges who have spent time, even today when today is a holiday. Instead of spending time on the busy hours, they have spent time just the comparison. Thank you very much, sir.
Thank you, sir. Thank you,
madam.
everyone. I now request the teams to kindly leave this meeting.
Thank you.
Thank you, ma'am.
Thank you, sir.
Sorry.
Thank you, ma'am.
Sorry for keeping everyone waiting.
I now request the judges to kindly share the score sheet with us as soon as possible. And you may discuss the scores as you please
Everyone,
with amongst yourself.
I, on behalf of Adhipatra Padasar Delhi High Court Review,
Yes, sir.
our honorable judges, Honorable Madam Mary Puspata,
You have recorded
Delhi High
what
Court,
you
Honorable Mr. Justice Amit Sharma, Honorable Judge Delhi High Court, Dr. Balbir Singh, Additional Solicitor General for
Charger.
Yes, sir. Justice Srivastav.
Yes.
Ji. So, what's your view, sir?
सर बताइए, मैंने तो मार्क्स लिखे हैं because
जी.
on page there was a marking criteria and everything.
हाँ.
So I have given the
You are
marks
not
accordingly.
audible. Justice Srivastav, you are
Hello?
not audible. You are not audible, sir.
Unmute.
Unmute, yes.
Yes. Yes, Justice Srivastav, what's your... Have you given the score?
I'm counting it, sir. Just have 1 minute more. 160 marks to speaker 1 of the team first.
Pardon?
160 out of 200 to speaker 1 of the team 1.
160.
60.
Okay, sir.
160.
Ji. Until
No, but is it to be marked like on page 8? There is a marking criteria.
Yes.
To my understanding, each speaker has to be marked, given marks. Okay.
Yes, yes.
Yes, but finally we can tell the marks so that we can tell which team has scored higher.
Okay, total marks. Okay.
Total marks.
And equally, speaker 2 will have also 160 marks.
Yeah, each speaker also has to be given marks.
Yes. But team, first we have to tell that how much the prosecution has scored, both the out of 200, I think Justice Srivastava has given 160.
Yes.
One to prosecution. Team
yes.
10. And how much to team defense team, sir?
Not much lesser, but the team 2, the defense side, will have scored 155.
155. Okay, sir. Ms. Kalra, what's your?
Yeah, I'm just giving.
Please.
I'm just adding.
Please.
So my defense, I have given 86 marks, and to state it 88.
To speaker 1 and speaker 1 86.
No, not speaker 1, but the entire team defense 136 out of 100. Speaker 1 and 2 I'll give separately.
Maybe we can later give it. We can tell that we still. So how much you have given to the prosecution?
The state I have given 68 out of 100.
68 out of 100.
Prosecution state ko. That is team 107. And for defense, I have given 86 marks. That is 136.
Okay. So as per you, the winner is the defense.
Yeah. Because otherwise our marks will be added and then it has to be, average has to be taken out.
How I have marked is, I think me and Justice Srivastava have given more marks to the prosecution.
Judges, if
but
may
I think
interject.
average will be taken. Average will be taken.
Judges, may I interject? It is speaker 1 out of 100, speaker 2 out of 100. Teams will be given out of 200. Both the teams. This is the way of mark. Yes.
I have given to prosecution 148 out of 200.
Yes, yes, sir.
And to defense 138 out of 200.
Okay, sir. And sir, I just request you, when you fill your mark sheets, just scan it and send it to us so that we can keep it a recorder.
I don't have anybody at my office. I'm doing it from my residence. Send it tomorrow. Or if you have any mobile number, I can send it on the number.
Okay, sir. I'll just provide you with the mobile number. I am dropping a mobile number in the chat box. You please.
Will you tell me? I'll note down. You tell me, I'll note down.
You please note down,
yes,
Akash, note down my marks also. I had to double them. It is out of 200. For state, I have given 136. And to defense, I have given 172.
Yes, ma'am. Please send the score sheets and just please note down my number if you.
Okay. Yes. Okay. Yes. Yeah.
Because we have to declare the results and the final round will be held today.
Yeah.
And the best speaker also we have to find out. That's why division has to be as per speaker, per team, per speaker.
Tell me the number.
Yes. Yes, sir. 99.
99.
689.
99689.
Double four.
What is the
It's
last?
one.
44
861.
861.
Yes, ma'am.
Double nine
Please
eight
send the.
nine double 4861.
Yes, sir. Please send these score sheets on this number.
I'm just saying.
Just click a photograph and. Yes, sir.
It is. Right, Justice Srivastava, nice meeting you.
Yes,
I think I can congratulate you also for NCLT.
exactly, sir.
Thank you. Very good. Congratulations.
Thanks.
Looking forward to see you in Delhi soon.
Exactly.
Thank you. Thank you, Ms. Kalda. It was nice
Thank
meeting you.
you, sir. Thank you. Same here.
And thank you, Ms.
Thank you to
Vajpayee.
everyone. Thank you.
Thank you.
Thank you, everyone. Namaskar.